ठीक 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 है, ठीक है ना। और बोल रहा है हेलो हेलो चेक। फुल है यार, तो क्या फुल कराओगे। हेलो हेलो चेक 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 चेक। हेलो हेलो ठीक है, ठीक है। चेक 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 चेक।
Ladies and gentlemen, good evening. I would like to extend a warm welcome to everybody here today. We are very grateful to the Chief Justice for agreeing to come here and deliver the lecture today. I'd like to welcome all the honorable judges of the Supreme Court and of the High Courts. I would also like to welcome all the retired judges, the office bearers of the Supreme Court Bar Association, the Advocates on Record Association, the Delhi High Court Bar Association, and all my colleagues, senior advocates and advocates, as well as the members of the press. I think if everybody is seated, then we can begin the proceedings today. I'd like to invite Mr. K.K. Venugopal, Senior Advocate, former Attorney General for India, to make the opening remarks.
At 93 years, I have to get my legs oiled because they don't move very freely. Honorable Chief Justice of India, Honorable Judges of the Supreme Court, Judges of the High Court, present and past, the office bearers of the Supreme Court Bar Association, the office bearers of the Advocates on Record Association, my colleagues at the bar, and my friends, ladies and gentlemen. I think it's one of the great things that has happened to me and in memory of my father, that the Chief Justice of India, Justice D.Y. Chandrachud, has agreed to give this lecture. I've had very many lectures previously by Sandra Day O'Connor, Judge of the Supreme Court of the United States, by Justice Nazim Hassan Shah, Chief Justice of Pakistan, Justice Lord Slim, then Lord Goldsmith, and very many others. All of them would give a talk generally on any subject which they wanted to speak on. And in doing so, they would casually mention M.K. Nambyar and a little few facts about him. But this is the first time that the speaker has said that he is going to speak on an M.K. Nambyar-centric topic. And that topic was something which I had not thought of earlier. The topic is foresighted M.K. Nambyar, and about the original intent of the Constitution as to what he has done in regard to changing the original intent. Perhaps, I do not know. We have to start listening to his speech. But from what we have seen in the past, you can rest assured that it's going to be an excellent speech. Now, Mr. Vaidyanathan is here, and he had originally asked Honorable Chief Justice, because he was closely associated with my father, M.K. Nambyar, to give the speech on the M.K. Nambyar Memorial Lecture, and that too in Tanjavur, and Tanjavur in a university there called, one of the university, a very, very well-known university. Now, when I heard about it, I thought that it's more fitting if I am able to persuade the Chief Justice to give the lecture in Delhi. And therefore, I requested Mr. Vaidyanathan, please give up your priority and allow me to have the Chief Justice give the speech. And he agreed. And that is very gracious of him. But of course, I just heard the Chief Justice tell him that he still wants to go to Tanjavur because he thinks that's a beautiful place, and with all the temples which are very famous and so on. And therefore, I do hope that he will go to Tanjavur and give a second lecture on M.K. Nambyar. Now, I would like to speak a few words about my father's life. So far as the Chief Justice is concerned, he is going to speak about his law career and what he has done for the purpose of the outstanding things that he has done in regard to the cases that he has handled. My father was born to a very affluent landlord's family. And you must remember that he was born in 1898. And therefore, in the 28s and so on, the landlord's families could not think of anything other than their children should look after the lands, because they had vast lands. And therefore, the education stopped at 6th standard. But so far as my father was concerned, he was not prepared to accept that. And therefore, he went against tradition, insisted that he should continue his studies, and went to St. Aloysius School, then to the government college in Tanjavur, and thereafter to the Madras Law College. And finally, he was lucky that so far as his Tarwad is concerned, that is the family, which was a very affluent one, had a bitter feud with another family which was equally rich, and the two were finally locked horns in the Privy Council. Therefore, his Tarwad suddenly realized that they had a lawyer with them, and therefore they said, please go and instruct the Queen's Counsel in regard to our case. Therefore, he prepared the case thoroughly, went to London, instructed the Queen's Counsel, won the case, which is reported. And thereafter, he decided he will do his master's degree in constitutional law and administrative law. He stood first in the London School of Economics. And with that, with flying colors, he came back to Mangalore. He was made a public prosecutor, government pleader, and therefore for 11 years he continued in that particular post. Thereafter, he had a further bit of luck, and that was because Justice Govinda Menon of the Madras High Court was elevated to the High Court bench of the Madras High Court, and he wanted somebody to take over his practice of both criminal cases as well as civil cases. Therefore, he thought of my father, and therefore he asked him, Mr. Nambyar, will you come over to Madras from Mangalore? You have to realize that Mangalore at that time was a very small town, and so far as that was concerned, it was a district court, and he was public prosecutor, government pleader there. So when he was offered this, he jumped at that opportunity, and he got into his car straight away, drove all the way to Madras, took over the practice, and 2 years later, he was arguing a death sentence case, and he was relying upon very, very intricate questions of constitutional law. And V.G. Rao, who was a barrister in charge of A.K. Gopalan's case, was surprised that an official lawyer practicing in the district courts could possibly come over with all this original thinking on the varied issues in regard to the constitution and criminal law. And therefore he asked my father, Mr. Nambyar, will you be prepared to handle A.K. Gopalan? And you should remember that's the first case, and therefore you will have to make your mark and see that the case is put over as a first case among a batch of about 20 cases. Father agreed, and for 1 month both of them sat and prepared the case thoroughly. And I remember as a young chap that there are a large number of books, US Supreme Court, English courts, Australian courts and so on, lying on the floor. And they prepared the case, and I think he did very well. And thereafter his name as a constitutional lawyer was made. And with that, a flow of constitutional cases came to him. He was practicing in the Supreme Court while being based in Madras. And thereafter, in the various high courts, the result was that his name became very, very famous as a constitutional lawyer. And this is what Sri Narendra said at the time of the reference by the full court when he passed away on the 18th of January, 18th of December, 1975. He said, Nambyar was one of the greatest lawyers that India has produced in the past. I have no doubt that the future generation of lawyers in India will venerate his name. And that was the status that he had when he passed away. And therefore, so far as I was concerned, I was lucky to be his son. And I am today what I am on account of my father. He took me under his tutelage, allotted cases to me, perhaps discriminating in my favor and against the juniors whom he had for decades. But of course, I don't think he minded or I minded. And therefore, finally, I built up my practice. And therefore, I think I'm very lucky and to have a father like him. And today, I'm so happy that the Chief Justice of India, because no Chief Justice has so far delivered his memorial lecture. And Chief Justice D.Y. Chandrachud has agreed to do so, and I'm extremely grateful to him. Thank you.
I would now like to invite Mr. C.S. Vaidyanathan, Senior Advocate, to make a few remarks.
The Honorable the Chief Justice, Justice Chandrachud, Honorable Judges of the Supreme Court, Honorable Retired Chief Justices and Judges of the Supreme Court, Honorable Chief Justice of the Delhi High Court, Honorable Judges of the Delhi High Court and retired judges, fellow senior counsel, my advocate friends, my revered guru, Mr. Vanugopal, who is 93 years young and still active. He has written the book about his father with the assistance of two of our young colleagues here. And it has a wealth of information. I had the good fortune of joining Mr. Vanugopal in 1974. And Ms. Nambyar was still alive. For about a year and a half, I had the opportunity to interact and assist Mr. Nambyar. I noticed that he had meticulously prepared all his cases in a green notebook with his own handwriting, green ink. And whenever the case was called out, he was always ready because his notes were there and his papers were there and he didn't need anything else. He was ready to go and argue. Of course, at that time, when I joined, he was taking up very few selective cases. Some cases like, fortunately or unfortunately, we had the time when detention law was extensively used from the amendment of MISA in September 1974 and thereafter, after emergency. And Mr. Nambyar was well known for appearing in preventive detention matters. Therefore, he was most sought after all over the country. And he was appearing for Shukar Narayan Bakia, Haji Mastan, a number of others in Bombay High Court, and of course in Supreme Court in ADM Jabalpur. During the midst of ADM Jabalpur arguments, he took ill, and Mr. Venugopal and I flew back to Madras because he was already in the hospital. But I want to mention about one or two cases. I had worked as an executive, as a senior management trainee in DCM, so I knew something about finance also, management finance. So when Sakti Sugars came up with the case in regard to sugar price fixation, where KSV and Company was very involved in the Karnataka High Court, I had prepared a petition with the calculations and all that, and I took it to him. I thought I had worked up everything. So he asked me, have you taken into account the revenue that Bagas will fetch? Because one of the things that the other side will raise is that apart from what you have expended, the costs by way of sugarcane and others, there will be some realization also from the byproduct, Bagas. So this was something, you know, the minute detail which he had gone into. He applied his mind, and then, so I sat back and then got the information and then put it in, and so that nobody will raise a question. He always, Mr. Nambyar always tried to anticipate what the other side will say. And that's why if we gave him 10 books with some proposition, at least 8, 9 will be rejected and he will pick out one, because even if there is one sentence which could be used against us by the other side or which will be picked up by the judge, he will say, no, we can't use that. So, I mean, this was the kind of extensive preparation that he used to do. And it was a lesson for us. And the way he would go and observe the judge before he starts the arguments, and then prepare himself as to, depending on the judge, what best will be the point that should be addressed. When I read Mr. Venugopal's book, one of the thoughts that came to me was, what was it that made him the constitutional legend that Mr. Nambyar became? Starting from a feudal family, being educated at home by Elizachans, and then going to a Catholic school in Mangalore. So the English education exposed him to a larger vision. But from the cosmopolitan Mangalore, he went to a completely conservative Kumbakonam. And he studied in a college which has thrown up some giant intellectuals. Srinivas Ramanujam, the mathematician. Right Honorable Srinivas Sastry, a doyen during the Freedom Days. Uve Swaminathan, who was known as Tamil Thandai, father of Tamil literature, because he unearthed so many of the old Tamil literature. That was the college. So the kind of praise that he was in threw up so many giant intellectuals, and that would have helped him. And then he went to Madras, and we are today living in a fast world. We can travel to London in 8-9 hours. But he must have traveled 6 weeks in a ship when he went there. And when you go there, you don't have family, you didn't have friends. These are all unfamiliar faces that you are with. The only companion that you will have is books, otherwise solitude. It gives you a lot of time to think. And that was during the time, soon thereafter, it was in between two wars, First World War and Second World War. And the thoughts all over the world was about liberty, equality, and fraternity. I think that got so ingrained in him and flowered when he did his master's in London School of Economics and was called to the bar in Lincoln's Inn. So when he came back, having done his master's in constitutional law and administrative law, he would have been waiting for an opportunity to try his skill in these areas, which he got in 1950. But I think one consistent point about which the Chief Justice is going to speak about, and I don't want to, we would find in the formative years of the Supreme Court, if emphasis was laid on liberty and equality, I think Mr. Nambyar had a big role in it. And let's now listen to the Chief Justice. Thank you all very much.
I would now like to request Honorable the Chief Justice of India, Chief Justice D.Y. Chandrachud, to deliver the 2024 M.K. Nambyar Memorial Lecture.
Before the Honorable Chief Justice commences his speech, I would have to make an announcement. I had authored a book, the biography of my father, the constitutional, I think it is a constitutional visionary. And I had the assistance of two very young lawyers. One was Surit Parsarthi, who wrote about the case law, and the other was Suhasini Sen, who wrote about his personal life. I would like both of them to come forward and present a bouquet as well as a small little plant, a bonsai, to the Honorable Chief Justice as a mark of our appreciation.
A very good evening. Mr. K.K. Venugopal, Senior Counsel and the Doyen of our Bar, former Chief Justices of India, our former Senior Judges of the Supreme Court, my distinguished colleagues, Chief Justice of the Delhi High Court and all other judges of the Delhi High Court, Mr. C.S. Vaidyanathan, Krishnan Venugopal, and all the members of the bar, senior and junior, who are present here. I was a little disappointed at the memento which I got. For all our sobriety, or deemed sobriety, which judges are expected to have, you always wonder what memento you're getting at these events. My wife always tells me that you're going to go back to a 2.5-bedroom house, so please keep mementos out of the house. But I was hoping that Mr. Venugopal would present to me an autographed copy of the book on his father, which he has written, but I'm going to get that out of him soon. I must begin by telling you about a little story of my association with Mr. Venugopal, Mr. K.K. Venugopal. When he was running from court to court in the Supreme Court, and we were young lawyers, we'd go and brief him in his house in Niti Bagh. And that association continued. We ever so often go to the court in the afternoon, sit when he was arguing something, and just watch him. Watch the greats of our bar unfold a constitutional argument. Years later, when I became Additional Solicitor General of India in 1998, I was overawed by the thought that I had been briefed by the Union of India to oppose him in a very interesting case where he was appearing for Standard Chartered Bank, and the point was, can you prosecute a bank where the punishment is essentially imprisonment? But we were opposing each other for a week, and after the arguments were over, on the Friday, my father called me up in the evening and said, on your way home, you must come and drop by for 2 minutes. So I went home, and he says, I got a call from Venu, and he said that, Judge, as a former judge of the Supreme Court, I'm sure, you're rather keen that your son has been offered judgeship, and he has said yes. But I have one suggestion to make to you. He says, don't make a mistake of asking him to become a judge of the High Court. Well, he reminded me of this when I became a judge of the Supreme Court, and we exchanged letters then. I'm not sure whether I would have been happier if I had listened to his advice. But there are so many ifs and buts which define our existence. But truly, it's a great honor to be here, Venu sir. This is the second time I'm delivering the M.K. Nambyar Memorial Lecture. The first was at the NUJS Kolkata a few years ago when I spoke in his honor. But I can assure you I'm not replicating the same speech over and over again. Because when you speak too often, you run out of ideas. But this time I thought I'd speak about the foresighted Mr. M.K. Nambyar, Constitutional Journeys Beyond Original Intent. It's a pleasure and honor to be speaking in the memory of the inimitable Mr. Nambyar, someone who has been an inspiration to generations of lawyers and judges, including my humble self. My father would always tell me that there were two lawyers during the time that he was a young member of the bar in Bombay who were always watched, and the court would be packed to capacity when they came to Bombay to argue a case. Kanhaiya Lal Mishra from Allahabad and Mr. M.K. Nambyar. Born in 1898 in the present-day Kasaragod district of Kerala, Mr. Nambyar stepped into the legal profession in the 1920s. He joined the chambers of the revered Sir C.P. Ramaswamy Iyer, a stalwart of the Madras bar. Sir Ramaswamy was the force behind the progressive temple entry proclamation of 1936, which ended are embedded in the larger legacy of the Constitution itself. In my lecture today, I posit that Nambyar's journey is integral to the journey of our Constitution. First, I will make a brief reference to the enduring legacy of our Constitution. Second, I will argue that while a significant part of this legacy is attributable to the foresight of the framers of our Constitution, there is more to it. The Constitution continues to be relevant because it is sensitive to the changing needs of its constituents. Third, I will attempt to explore how Mr. Nambyar's arguments were seminal to this legacy and marked a departure from originalism and shaped our jurisprudence. First, on the legacy of our Constitution and the role of the framers. The Indian Constitution, simply put, exemplifies a bargain between countervailing values. Unlike, say, contractual bargains, constitutional bargains bind not only those who are a part of the framing process, but even to those who inherit the Constitution. At its framing, the Constitution carried the hope that it would afford stability and direction to democratic institutions while preserving flexibility to accommodate changing social realities. So when we look at the life of a lawyer, or for that matter, life of a judge, in retrospect in history, it's important that we understand the evolution of that life in the context of the society in which those principles, those visions and ideas were developed. That was a time when there was a fear of whether the nation itself would survive. And therefore, this great centralizing and centrifugal tendency that you find in the Constitution. The framers of the Constitution are crucial to deciding the terms of this bargain. Understandably, there is a sense of deference and presumptive validity attached to the process of the framing of all constitutions. This deference extends naturally to the framers' views, or at least what are believed to be their views about a constitutional provision. In his work on the American democratic system, Democracy in America, Alexis de Tocqueville extolled constitution making as a greater cause of celebration than the independence of the nation itself. He believed that while independence was a routine event, it was in the framing of the Constitution that the country showed itself capable of rising for a few moments to that lofty degree of renown, as he said. Unlike the American experience, the Indian Constitution was a break from a colonial past and represented the aspirations of a newly independent nation. The Constitution was deeply influenced by the values which stemmed from our independence movement, which were uniquely Indian. We find examples of this narrative about the exceptionalism of the framers as the force behind the Constitution and its persistence in the Indian context. As well, Granville Austin recorded that it was the charismatic leadership of the founding fathers of the Constitution that allowed it to work as well as it did. Likewise, Zachary Elkins and his distinguished colleagues have spoken in their work about the endurance of national constitutions. They argue that a constitution continues because it makes sense to those who live under its dictates. This understanding that the framing of the Constitution is a sanctified, once-in-a-century exercise that epitomizes creative social expression merits a somewhat critical consideration. Let me next dwell on originalism and the framers' intent. A sequitur of this veneration appeared in the context of the American Constitution, where increasingly reference were being made to the original intent of the framers of the Constitution. The debate between originalism and the idea of a living constitution has been a long-standing and contentious issue. In the context of the US Supreme Court, not only among legal scholars, but also judges sitting on the bench. At its core, originalism posits that the Constitution's meaning is fixed and should be interpreted based on its original understanding at the time of its adoption, giving primacy to the purported intent of the framers. Proponents of originalism on the bench, such as Justice Antonin Scalia, argue that this approach prevents judges from imposing their own values and biases on the Constitution. On the other hand, the concept of a living Constitution suggests that the meaning of the Constitution evolves and should be interpreted in the light of changing social values. Proponents of this approach argue that the broad language of the Constitution intentionally allows for flexibility and adaptation to future generations. They contend that originalism is overly rigid and ignores the complexities of modern society. A recent and contentious example of this debate is the decision of the US Supreme Court in Dobbs versus Jackson Women's Health Organization of 2022, which overturned the precedent in Roe versus Wade of 1973. The majority opinion, written by Justice Samuel Alito, employed an originalist approach in concluding that the right to abortion is not explicitly mentioned in the Constitution and is therefore not protected. In other words, the view taken by the majority was that the framers of the Constitution never intended to recognize this right. In contrast, the dissenting justices argued that the Due Process Clause of the 14th Amendment protects individual liberties, including reproductive autonomy, and that the Constitution's guarantees of liberty and equality should evolve to reflect contemporary understandings of dignity, autonomy, and equality. In this way, a rigid obsequence to the text of the Constitution and the purported intention of the framers, although tempting, can often result in a restrictive reading of citizens' rights. Similarly, in India too, there is sound principle behind a historical inquiry of the provisions and the intention of their inclusion by the framers. The discussions in the Constituent Assembly in India were unique in more ways than one. The members of this body represented the socially diverse fabric of the nation. For over 165 days, members of the Assembly discussed threadbare the provisions that now form a part of the Constitution. Often, members of the Constituent Assembly would propose amendments which involved alternate phrasing of various provisions. These were debated in the Assembly before the members voted on the final text. The debates were recorded for public consumption, offering a rare insight into the minds of the framers, an uncommon phenomenon for constitutional processes around the world. But such an inquiry should guard against originalism as a primary axis for interpretation. Even a limited inquiry of the original intent of the framers of the Constitution must be undertaken with great caution. In one of its dominant forms, originalism asserts that those who created the Constitution intended a definite effect, and all interpretation of the provisions must therefore conform to it. This primacy of the framers' intent is problematic for several reasons. First, originalism wrongly presumes that the intent of the framers can be precisely ascertained. It presumes that history speaks in one voice, and this voice is capable of consistent interpretation by different readers. But as we know, history speaks in different voices. History does not consist of a monolithic presentation of societal values and opinions. And then history is always perceived by those who look at history in a different context. The Constituent Assembly consisted of people with different political and social leanings, including socialists, Gandhians, Fabians, and cultural nationalists. Each one of them had differing and sometimes countervailing views about the dominant philosophy of the Indian Constitution to be. The voluminous Constituent Assembly debates are a record of all these varied forces, which are sometimes incompatible with each other. And therefore, it is often difficult to infer a clear and singular interpretation from the text of the debates alone. Second, a very distinguished scholar, Jack M. Balkin, writes that constitutional principles are often justified by stories about decisions and actions taken in the past. The logic goes, we do this now because we did that then. Unpacking constitutional questions necessarily entail the story about the past, about hopes, goals, and fears. But answering these questions may not necessarily require us to tether ourselves to the elusive original intent of the framers. Should a constitutional court freeze the content of constitutional guarantees and provisions to what the founders perceived? The Constitution was drafted and adopted in a historical context. The vision of the founders was enriched by the histories of oppression and subversion of human rights in India and across the world. The framers were conscious of the widespread abuse of human rights by authoritarian regimes in the 2 world wars over 2 decades. They were equally conscious of the injustice suffered under a colonial regime and the more contemporary horrors of partition. Yet it would be difficult to dispute that many of the problems which contemporary societies face would not have been present in the minds of even the most perspicacious of draftspersons. A distinguished American scholar, Bruce Ackerman, argues in his work that generations are the basic units of constitutional evolution. Constitutional law is created by a conversation between generations. As the common cliche goes, one cannot step into the same river twice, unless it is, of course, Justice Sapre who goes to the Narmada ever so often for his dip in the river. No two generations are reading the Constitution in the same social, legal, or economic context. No generation, including the present, can have a monopoly over solutions or confidence in its ability to foresee the future. As society evolves, so must constitutional doctrine. The institutions which the Constitution has created must adapt flexibly to meet the challenges in a rapidly growing knowledge economy. Third, besides subjectivity, the problem with an unreasoned tethering to the framer's intent is that it renders the Constitution susceptible to inflexibility. The Constitution was never meant to be a set of ironclad rules governing the social and legal relationships of her citizens. It was meant to be a broader framework of principles which would constitute the bedrock of our new political reality. Paradoxically, fixation with the original intent of the framers is contrary to their own vision. A distinguished judge of the US Supreme Court, Justice Louis Brandeis, said that the framers of the US Constitution believed courage to be the secret of liberty. They were not married to only singular interpretations of the constitutional text. A conservative reading of the framers' intent then belies their foresight. It was never their intent to lock the provisions of our Constitution in place for eternity. This would have militated against the necessary flexibility, which is the key for constitutional longevity. The framers hoped that with time, we would acquire greater insight and use that to explore the transformative potential of the Constitution. Dr. Ambedkar himself believed that the Constitution was a flexible, workable, and resilient document, and that its spirit was not the spirit of its founding moment, but rather its spirit was the spirit of the age. Now, where does Nambyar's foresight then interpose itself in this background to our evening's conversation? The criticisms of relying solely on the intent of the framers have now been widely accepted in Indian constitutional jurisprudence. But back in the 1950s, with little jurisprudential guidance, Mr. Nambyar's foresight was truly remarkable. From arguing the first ever constitutional decision before the Supreme Court, to drawing up the lead petition in Keshwanand Bharati, to arguing in Keshav Singh, M.K. Nambyar's journey as a reader of the Constitution can be traced in many a jurisprudential landmark. In 1949, before he began practicing before the Supreme Court, Nambyar was defending his clients who had allegedly committed the offense of cheating in Travancore. Since Travancore was considered outside British India at the time, the Indian Penal Code applied to these accused persons only with a prior sanction for prosecution. The accused were never granted the prosecution sanction. However, by the intervening Independence of India Act and the consequential accession of Travancore to the Dominion of India, an amendment to the IPC, the sanction requirement was obviated. Barely a few months old at the Madras Bar, Nambyar challenged the amendments to the IPC and argued that notwithstanding those amendments, without a prior sanction before the accession, his clients could not be prosecuted. His argument was rejected by the court, yet Nambyar's position was secured as someone who could link seemingly banal criminal and civil matters with constitutional underpinnings. It was during one of his passionate defenses of a death row convict that Nambyar caught the attention of V.G. Rao, a towering barrister who would serve as the bridge between Nambyar and the first ever constitutional case of independent India. Having witnessed Nambyar's intricate eye for constitutional argument, V.G. Rao suggested that he handle the case of A.K. Gopalan before the Supreme Court. Nambyar's reading of due process into Article 21 of the Indian Constitution, while arguing the A.K. Gopalan case, was to become his foremost contribution to Indian constitutional jurisprudence. Let me summarize very briefly the facts of A.K. Gopalan. A.K. Gopalan, a prominent leader of the Communist Party of India, was preventively detained in 1941. 6 years later, even as the country gained independence and all British detainees were liberated, A.K. Gopalan found himself continuing to be detained. The oppressors changed, but the law was wielded equally arbitrarily. Gopalan lamented that once a member of the freedom movement, he was compelled to celebrate independence in a paradoxical, continuous, and oppressive detention by Indians and not by the British. V.G. Rao was handling Gopalan's case before the Madras High Court. He invoked independent India's new constitution to petition the Supreme Court in the matter. He chose Nambyar, barely 2 years old at the Madras bar, to pursue Gopalan's remedies under the new constitutional regime. A doyen of the bar himself, V.G. Rao's choice of counsel before the Supreme Court was rather surprising. Nambyar, a lawyer who had never appeared before the federal court or the new Supreme Court, swiftly rose to the occasion. V.G. Rao was so impressed by Mr. Nambyar that he chose him to even lead the arguments instead of stalwarts at the Delhi bar. Due process was a principle of substantive law that stemmed from the 5th and 14th Amendments of the American Constitution. The rule essentially placed limits on the legislative, executive, and judicial powers of the state and enjoined it with the responsibility to frame not just any processes, but just processes. Aware of the US experience, the Indian framers were hesitant to include such an omnibus restraint on the legislative powers. The principal advisor to the Indian Constituent Assembly, B.N. Rao, took the proposed first charter of the Indian Constitution to the experts in the US. Justice Frankfurter of the US Supreme Court objected to Rao's borrowed phrase, the due process clause. In 1948, the first draft constitution conspicuously omitted the phrase due process of law and replaced it with procedure established by law, a phrase which the current constitution contains in Article 21. Heard in the first month of the inception of the Supreme Court, A.K. Gopalan's case presented a unique interpretational challenge. Appearing for the detinue, Nambyar argued that Articles 14, 19, and 21 ought to be read as a set of guarantees vested in an individual. On due process, the Constitution had clearly deviated from the US model. Yet, despite the obvious limitations posed by the text of the Constitution and the Constituent Assembly debates, Nambyar argued that procedure established by law in Article 21 was jus, justice, not just lex or principles of law. Relying on the arguments of Daniel Webster in the 1819 US Supreme Court case of trustees of Dartmouth College versus Woodward, Nambyar argued that a law with mere legislative sanction was not per se beyond reproach. As against this, his adversary in the case, Motilal Setalvad, the then Attorney General for India, argued that Nambyar's reading was unsupported by the obvious intent of the framers of the Constitution, which was not to adopt the US model of due process. A tongue-in-cheek tale has been passed down at the bar through the years. While making these submissions, Mr. Nambyar, in his characteristic flair, said, "I seek permission of my lords to quote from an authoritative book from a respected author." Reading the palpable tension around the Attorney General, the Chief Justice got a whiff of what was to follow. Mr. Nambyar, of course, was citing a passage from the Attorney General, Mr. M.C. Setalvad's book on civil liberties. Chief Justice Kania smiled and asked if it was really necessary to do so. He didn't want the pitch to be queered in the calm environs of the Chief Justice's court. Justice Mahajan, on the other hand, egged on Mr. Nambyar, who read many passages from Setalvad's book which ran counter to his arguments before the court in support of the preventive detention law. Years later, Palkhiwala's recourse to Sirvai's book to rebut Sirvai's argument in court reportedly ended a long friendship at the bar. I encountered something similar in my court this afternoon. Neither lawyers change, nor does the quality of the discourse in our court. Riveting as this exchange must have been, Nambyar's endorsement of due process did not immediately find favor with the majority. Nambyar's view, however, was accepted by Justice Fazal Ali, whose minority opinion drew heavily from Nambyar's interpretation of Article 21. It was nearly 2 decades later, in the R.C. Cooper decision, and 3 decades later in Maneka Gandhi, that the interpretation by Nambyar would find judicial force. This was not the only example of Nambyar leading constitutional courts towards an interpretation that was foresighted and reflected a departure from originalism. In addition to his arguments about due process back in the 1950s, Nambyar argued before the Madras High Court in a seminal decision, V.G. Rao versus the State of Madras, in 1951. The case pertained to a government order by which an education society was declared as an unlawful association for allegedly constituting a danger to the public peace. V.G. Rao was the general secretary of the society. Nambyar argued that the power was exercised arbitrarily and thus violative of Article 14. In other words, arbitrariness in Nambyar's exposition was antithetical to the guarantee of equality. We know now that this approach to Article 14, in contrast to the traditional classification test, has gained wide currency in Indian jurisprudence. In the earlier years of our jurisprudence, inspired by the 14th Amendment of the US Constitution, the Supreme Court, however, devised the classification test to determine the compliance of a law with Article 14. This test entailed asking 2 questions. Firstly, whether the classification made was based on an intelligible differentia, and second, whether the classification has a reasonable nexus with the object the law sought to achieve. The assumption behind this approach, which Nambyar doubted well before its time, is that the right to equality is invoked only when there is a classification. In the 1970s, in E.P. Royappa, and even before that in Chiranjit Lal Chaudhary, the understanding of Article 14 evolved to include the arbitrariness doctrine, and there has been no looking back. Following this trend, in more recent decisions such as Shaira Bano and Navtej Singh Johar, the Supreme Court has further endorsed an idea of equality which has transcended the traditional notion of classification and rooted the doctrine in concepts such as manifest arbitrariness. The landmark High Court decision in V.G. Rao reached the Supreme Court in 1952. Although the bench did not have the privilege of Nambyar addressing that court, Justice Patanjali Shastri's opinion remarkably echoed Nambyar's foresight. This seminal judgment is widely regarded as an early effort in our jurisprudence to delineate the contours of reasonable restrictions on fundamental rights, particularly under Article 19. In a frequently cited observation, Justice Patanjali Shastri held that when assessing the reasonableness of laws restricting fundamental rights, both substantive and procedural aspects must be scrutinized. He identified key factors to consider, such as the nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied, and listen to this carefully, the disproportion of the imposition and the prevailing social conditions. This test laid down by Justice Patanjali Shastri, inspired by Nambyar, in many ways, laid the groundwork to evolve the proportionality doctrine used by constitutional courts all over the world to evaluate the reasonableness of restrictions on fundamental rights. Similarly, in A.K. Gopalan, Nambyar had argued that the fundamental rights are not silos unto themselves. The argument was rejected by the majority in A.K. Gopalan, but subsequent decisions of the court in Cooper and Maneka Gandhi wholeheartedly endorsed the idea that fundamental rights are not independent of each other. Hence, a law depriving a person of personal liberty and prescribing the procedure for that purpose under Article 21 has to stand the test of other fundamental rights contained in Articles 14 and 19 as well. This approach has informed the recent jurisprudence of the Supreme Court, including the decision of 9 judges in Puttaswamy, recognizing a right to privacy in Part 3. Undeterred by the outcomes in A.K. Gopalan, Mr. Nambyar consistently pursued his understanding of Articles 14, 19, and 21. The Indian Press Emergency Powers Act of 1931 allowed the state to demand security from publishers of material that supposedly incited violence. Mr. Nambyar unsuccessfully argued before the Madras High Court that the provisions of the law were overbroad limitations on the freedom of speech and were then unsustainable under Article 19(1)(a). However, in 1954, again before the Madras High Court, he successfully argued this time that Section 49A of the Madras Police Act, which criminalized publications of information related to wagers, violated Article 19(1)(a). His repeated dents to broaden the ambit of fundamental rights and their cohesive reading culminated in Bennett Coleman, his last major constitutional case before the Supreme Court. Mr. Nambyar, appearing alongside none other than Mr. K.K. Venugopal, successfully challenged the speech inhibitory newspaper control order of 1962. Today, his repeated efforts to highlight the interlinked nature of fundamental rights have borne fruit and have become an integral part of our jurisprudence. In fact, we have moved beyond recognizing that the fundamental rights gain color from each one another. We have devised tests to balance one right against the other in situations of potential compatibility or incompatibility. For instance, in the recent decision of the Supreme Court in Association for Democratic Reforms, the Supreme Court was dealing with apparently countervailing rights. The donor's right to privacy on the one hand, and the electorate's right to know about political donations on the other hand. The court applied the double proportionality test and struck down the electoral bond scheme. In many ways, it was Mr. M.K. Nambyar's foresight in A.K. Gopalan that lies at the very core of this jurisprudential journey. The idea that a factual situation or state action only creates consequences on one single fundamental right is now an unimaginable proposition of law. But now we are stepping into a new world with new problems. Nambyar's approach echoes with the jurisprudence around several jurisdictions, including notably the constitutional courts of Canada, the United States, and Australia, which have used the metaphor of a living constitution in their judgments. The metaphor used in Canada is that of a living tree, which postulates that the constitution is capable of growth and expansion. But this must be within its natural limits. Just like a large banyan tree, the tree is rooted in past and present institutions, but must be capable of growth to meet the future. As new problems emerge, the branches must be capable of spreading to accommodate the new interpretations of the law. For instance, in reference-free jurisdiction of Parliament to regulate and control radio communication, the Supreme Court of Canada was called upon to decide the authority of the Dominion to legislate on a subject which ostensibly fell within the provincial legislative jurisdiction. To Chief Justice Anglin, it appeared that though Hertzian waves and radio communication were both unknown to and undreamt of by the founders, every effort should be made to find some head of legislative jurisdiction capable of including the subject matter. Technology, as we experience it today, is far different from what it was in the lives of the generation which drafted the Constitution. I'm sure all of you would agree when we say that artificial intelligence was perhaps unknown to the founding fathers and mothers of the Constitution. Information technology, together with the internet and social media, and all their attendant applications, have rapidly altered the course of life in the last decade. Today's technology renders models of application of a few years ago obsolete. Hence, it would be unjust both to the drafters of the Constitution as well as to the document which they sanctified to constrict its interpretation to an originalist interpretation. In India, we describe the Constitution as a living instrument, for the reason that while it is a document which enunciates eternal values for our society, it possesses the resilience necessary to ensure its continued relevance. Its continued relevance lies precisely in its ability to allow succeeding generations to apply the principles on which it has been founded to find innovative solutions to intractable problems on their times. In doing so, we must equally understand that our solutions must continuously undergo a process of re-engineering. Another significant example is the evolution of environmental constitutionalism, which lies at the confluence of constitutional law, international law, human rights, and environmental law. The world today stands in a precarious situation. International bodies such as the United Nations Government Panel on Climate Change have raised alarm bells and contend that the impacts of climate change could be irreversible by 2030. The International Organization of Migration estimates that millions of people will be displaced by climate change, potentially causing a climate refugee crisis. The extent of environmental degradation and the very real existential threat caused by climate change was, of course, not foreseeable by the framers of our Constitution. But as the crisis becomes more apparent, courts are increasingly becoming aware of the ramifications of the environmental crisis. In M.K. Ranjit Singh, the Supreme Court recognized a right against the effects of climate change. Without a clean environment which is stable and unimpacted by the vagaries of climate change, the right to life is not fully realized. The right to health, which is a part of the right to life, is impacted due to factors such as the air pollution, rising temperatures, droughts, storms, and floodings. The inability of marginalized communities to adapt to climate change or cope with its effects violates the right to life as well as the right to equality. For instance, if climate change and environmental degradation lead to acute food and water shortages in a particular area, poorer communities will suffer more than the more affluent ones. The right to equality would undoubtedly be impacted in each of these instances. The understanding of the Constitution as a living document aids constitutional courts in understanding new and novel problems. It also facilitates the court in finding a jurisprudential basis for solutions to existing social problems. Let's take the example of Article 17 of the Constitution, which abolishes untouchability. The context of this provision was the stratified society we found ourselves in. Caste was an important axis of social organization, and those who found themselves at the bottom of this occupational social hierarchy were subjected to untouchability solely on account of their caste. The basis, remember, was occupational hierarchy of castes and the ritual impurity associated with certain occupations. The framers of the Constitution debated the scope of this prohibition in some detail. The argument was essentially that if untouchability were not defined and limited in its application to caste, it would lead to unwarranted, overbroad applications in the future. K.T. Shah, a member of the Constituent Assembly, had in fact warned against its potential use to include women who were subjected to notions of purity and subordination comparable to occupational hierarchy. Privileging the historical context of occupational purity, the Supreme Court once believed that untouchability was tethered to caste-based untouchability alone. But in 2018, a bench of which I was a part was faced with this very interpretative conundrum. Reading through the Constituent Assembly debates, I concluded that the framers deliberately left untouchability untethered to caste, that Article 17 provides a guarantee against notions of impurity and pollution, and caste is only one manifestation. In conclusion, it is tempting to pit the framers' so-called original intent against the notion of living constitutionalism. Nambyar demonstrated that the solution lies between a complete abandonment of their vision and its uncritical acceptance. While Nambyar was meticulous in his understanding of the intent of the framers, he was never overcome by what the framers had envisaged. For instance, in Golaknath, Nambyar relied on the framers' intent to secure fundamental rights from parliamentary onslaught. He relied on H.V. Kamat's unsuccessful attempt to amend Article 368 to empower the parliament to alter fundamental rights. Therefore, he argued that there are certain implied limitations on the parliament's power to amend fundamental rights. Not even hopeful of an admission of the case, Nambyar's submissions managed to find a place in the dissent of Justice Subbarao. Then accepted only in part by Justice Subbarao, Nambyar's implied limitations theory came to be successfully argued in Keshwanand Bharati by none other than Nani Palkhiwala. The constitution of a country then, which is more than the mere text, is the foundation of this democratic culture and not the culmination of it. It merely stems from the framer's intent, but as Mr. Nambyar showed us, it blossoms in the lived realities of its constituents in their specific social context. As we celebrate the legacy of Mr. M.K. Nambyar, we must remember that there were many more like him who left their imprints on the Constitution, enhanced it, and infused it with meaning, and took the text to its legal destiny. The reason we celebrate them is that they read in between jurisprudential lines and traveled beyond the text, beyond obsequious obedience to the supposed intent of the framers. Legal scholars, lawyers, and people who use the Constitution to challenge the status quo and to assert their rights are as much a part of the constitutional order as those who framed it. A thriving democratic order must account for each of them, encourage more assertion, creative interpretation, and engagement with our constitutional culture. Mr. Nambyar's story then tells us that the story of the Constitution is a constant dialogue between generations of citizens. This dialogue reflects a dynamic process where each era interprets and applies constitutional principles to contemporary challenges and aspirations. It highlights how the Constitution evolves through judicial interpretation, legislative amendments, and societal change, adapting to new contexts while preserving fundamental rights and values. This continuous dialogue ensures that the Constitution remains relevant and responsive, reflecting the collective vision and aspiration of the people across different epochs. Lawyers play an indispensable role in shaping constitutional discourse. Until we took to live streaming, it was only the judges who left their footprints in the sands of time through their reported judgments. That's no longer so. Lawyers leave their footprints in the sands of time through the recorded video clippings of their arguments. And don't we wish that we had those arguments with the greats of the past era, like Mr. Nambyar or Palkhiwala. While judges have the ultimate authority to interpret the Constitution, it is the lawyers who craft and present the interpretative frameworks for the judiciary to consider. In this sense, interpretation is as much a job of a lawyer as it is of a judge, for without robust legal arguments and advocacy, constitutional interpretation would lack the necessary depth and diversity of perspectives. Unlike Mr. M.K. Nambyar, we will of course not have the privilege or the responsibility of starting on a blank slate. But I am hopeful that young lawyers will learn from his experience and view every opportunity before the court as a platform to enrich the Constitution. For this, future generations will forever be grateful, as we are, to Mr. M.K. Nambyar. Namaskar. Thank you.
It is my privilege, ladies and gentlemen, to deliver the vote of thanks this evening. We are very grateful to Honorable the Chief Justice of India, Chief Justice D.Y. Chandrachud, for his scintillating exposition of the interplay between the original intent of the framers and contemporary judicial interpretation in the light of today's values. His reflections on my grandfather, the late Mr. M.K. Nambyar's prescient contributions in A.K. Gopalan and Golaknath have significantly deepened my understanding of my grandfather's contributions to constitutional law and how he altered the understanding of the lawyers and judges of those days of what constitutional interpretation was all about. It is particularly fitting that Chief Justice Chandrachud should have delivered this M.K. Nambyar Memorial Lecture because he himself has made such a remarkable contribution to the field of constitutional law in his own judgments on behalf of the Supreme Court, which will be remembered, I think, for a long, long time. I'm thinking of his judgments in the privacy case, K.S. Puttasamy to Navtej Johar, to even his judgments on Indian federalism, for example, the Mada judgment, which overturned the seven-judge bench judgment in India Cements. A few of my friends have asked me if I had much interaction with my grandfather. I was very young when he passed away in 1975, but I do remember him as being a very gentle soul who kept his cool even in the face of the antics of his grandchildren. What stands out in my memory is he told me once that I should aim for the stars and hopefully I would reach the top of the coconut tree he was pointing at. Moving on to my experience of his professional work, I remember that he would work in his chamber from early in the morning, about 7:30 a.m., until the late evening for days on end, with just one or two of his juniors, his table piled high with books, which I learned later included law reports from around the world. But the late Justice Ranganathan of the Supreme Court, after his retirement, once told me that he doubted that Mr. Nambyar, with his slow and deliberate style, would have survived the thrust and parry of today's Supreme Court on miscellaneous days. On behalf of the organizers, we would like to thank the Honorable Judges of the Supreme Court, Chief Justice Manmohan of the High Court of Delhi and the Honorable Judges of the High Court who are here today, as well as the retired Honorable Judges of the Supreme Court and the High Court who grace this occasion today. We would also like to thank the law officers of the Government of India, the office bearers of the Supreme Court Bar Association, the Supreme Court Advocates on Record Association, and the Delhi High Court Bar Association who are here today. Thank you all also to all our friends, senior advocates, as well as members of the press for joining us today. And finally, and most importantly, on behalf of my father and myself, I would like to extend my heartfelt thanks to all my friends in my father's chamber as well as my own who have done such a wonderful job of organizing this event and ensuring that it runs smoothly. Truly a remarkable job. And now I would like to request the honorable judges, both past and present and past, to please join us for high tea in the Leaders' Lounge, which is on this floor, and all the others to kindly join us for high tea today, just outside this hall as well as on the floor below us. Thank you all very much for being here and for making this such a memorable and enriching event. Thank you.
It's all very complete gratitude.
Daughter in the United States.
Oh my gosh, wow. Of course I remember, we were all together in the law college, a couple of years, here and there.